Señoras y señores, tengan ustedes muy buenos días. Antes de iniciar esta ceremonia, agradecemos silenciar sus teléfonos celulares. La Facultad de Ciencias Jurídicas y Empresariales de la Universidad de la Frontera se complace en darles la más cordial bienvenida a la ceremonia de inauguración del Año Académico 2022, saludando en forma especial a las autoridades presentes el día de hoy, a la decana de la Facultad de Ciencias Jurídicas y Empresariales, doctora Paulina Sangüesa Martínez, al equipo directivo de la Facultad, directoras y directores de departamentos, directoras de escuelas y directoras y director de carreras, académicos, académicas, funcionarios, funcionarias, estudiantes e invitados especiales. Para dar inicio a este acto, les invito a ponerse de pie para escuchar el himno de la Universidad de la Frontera. A continuación, se dirigirá a ustedes con un saludo de bienvenida la decana de la Facultad de Ciencias Jurídicas y Empresariales, doctora Paulina Sangüesa Martínez.
Muy buenos días. Me voy a permitir quitarme la mascarilla, ya que voy a ser la única persona que va a hablar directamente acá en el micrófono. Muy buenos días nuevamente. Quiero expresar un saludo a todas las autoridades de facultad que nos acompañan el día de hoy, cuerpo académico y administrativo, comunidad estudiantil y muy especialmente a la señora Linda Greene por su generosidad al aceptar ser la expositora de la charla magistral de esta ceremonia de inauguración de nuestro año académico 2022. Me es tremendamente grato tenerles presente a todos ustedes en esta actividad, la que se constituye en un ritual emotivo ante un proyecto común que nos une. Una actividad que nos reencuentra y a partir de la cual, formalmente, damos inicio a un nuevo periodo académico en nuestra comunidad universitaria. Un periodo académico con una particularidad en el que retomamos nuevamente la presencialidad. Por ello, no puedo dejar de manifestar en primer lugar mi alegría al ver nuevamente el campus lleno de gente, lleno de estudiantes, de profesores, de funcionarias y funcionarios, compartiendo y conviviendo en los diversos espacios universitarios y aprendiendo no solo de contenidos y materias, sino que de vivencias y de experiencias en comunidad. Ha sido, en lo personal, muy emocionante verles nuevamente disfrutar de su campus y de su universidad. Ahora bien, no cabe duda que damos inicio a un nuevo periodo que de forma similar a los años anteriores se presenta no exento de incertidumbres y de grandes desafíos. Ante esta incertidumbre y estos nuevos desafíos, cada una y cada uno de ustedes, integrantes de nuestra facultad, ha tenido y tiene un rol preponderante en el avance del proyecto que nos hemos trazado. Y en tal sentido, nuestros progresos resultan al día de hoy significativos. ¿En qué hemos trabajado y en qué hemos avanzado? Comentaré 4 aspectos esenciales que, por supuesto, no abarcan en su totalidad el amplio trabajo desarrollado, pero que de manera general esbozan aspectos esenciales de nuestro compromiso de gestión. En primer lugar, abordamos los procesos de mejora continua de nuestras 3 carreras y de nuestro programa de posgrado existente, de forma tal de entregar de manera constante una formación de calidad, reconocida y pertinente a todos nuestros estudiantes. Avanzamos así también en un nuevo proyecto de posgrado en el área de las ciencias jurídicas. Continuamos creciendo en la generación de conocimiento, el cual se plasma en nuevos proyectos, en nuevas redes, tanto nacionales como internacionales, y nuevas publicaciones científicas que difunden los resultados de tales investigaciones. Y, además, nos vinculamos cada vez más con el territorio y con las necesidades que en él existen. Nuestras clínicas, por ejemplo, jurídica y empresarial, juegan un rol relevante en dicha acción. Ahora bien, sin lugar a dudas, el contexto y las circunstancias han sido complejas. Distintos hechos ocurridos durante los últimos años, tanto a nivel nacional como mundial, nos han sacudido fuertemente y nos hacen reflexionar respecto a distintos ámbitos de nuestro rol y de nuestro quehacer. Nos encontramos claramente en un punto de inflexión, en el cual redefinimos nuestro fondo y nuestras formas, nuestras reglas de convivencia, nuestro modelo socioeconómico, nuestros procesos competitivos y colaborativos y nuestra institucionalidad. Y en tal sentido, como facultad, resulta imperativo el plantearnos de forma permanente el cómo brindamos a todos nuestros jóvenes las oportunidades ante una sociedad tan cambiante y tan compleja. Existen desafíos claros que la formación que nosotros entregamos debe considerar. Ella debe estar cimentada en el conocimiento científico, riguroso. Ella debe aportar a la reflexión sobre nuevos paradigmas, nuevas ideas para la prosperidad de todos y no concentrada en unos pocos. Y ella debe abordar el aprendizaje en la construcción de confianzas en beneficio de la cohesión social. Nuestra facultad, no tengan dudas, está comprometida con la formación de profesionales, con la generación de conocimiento y la vinculación con el medio, orientadas a la construcción de una mejor sociedad, a través de su aporte al proceso de desarrollo que no solo potencie la esfera de la eficiencia económica, sino que también la de la equidad y la de la sustentabilidad. Buscamos plasmar en este compromiso, en las diversas actividades que desarrollamos, y esperamos que nuestros y nuestras jóvenes, los nuevos profesionales que como facultad formamos, sean embajadores de esta visión allá donde vayan. Finalmente, para no extenderme mucho más, me gustaría relevar 2 hitos o 3 hitos para nuestra facultad este año 2022, que le hacen muy particular. Se cumplen 25 años desde la creación de la carrera de Ingeniería Comercial. Asimismo, se cumplen 10 años desde la creación de la carrera de Derecho. Recordemos así también que hace un par de años se cumplían 50 años de nuestra carrera de Contador Público y Auditor. Y así también, me parece que este año cumplimos 5 años desde la puesta en marcha de nuestro programa de posgrado. Por lo tanto, creo que tenemos motivos o excusas para celebrar. Por tanto, confiada en que tenemos las capacidades para abordar los desafíos que se nos continuarán presentando, querida comunidad, doy por inaugurado el año académico 2022 de la Facultad de Ciencias Jurídicas y Empresariales de la Universidad de la Frontera. Éxito a cada una y a cada uno de ustedes. Muchas gracias.
Agradecemos las palabras de la decana de la Facultad de Ciencias Jurídicas y Empresariales. Para continuar con esta ceremonia, les invitamos a escuchar una presentación artística a cargo de la estudiante de la carrera de Ingeniería Comercial, Danca Briceño Torres, quien interpretará una versión en violín de Viva la Vida de Coldplay y Saturno de Pablo Alborán. Agradecemos y felicitamos a la estudiante de Ingeniería Comercial por su virtuosa presentación. En esta inauguración del año académico tenemos el honor de contar con la visita de la académica, investigadora y decana de la Facultad de Derecho de la Universidad Estatal de Michigan, Estados Unidos, doctora Linda Greene. Su actividad docente y académica se centra en el derecho constitucional, procedimiento civil, legislación, derechos civiles y derecho deportivo. Recibió su título en Educación para la Salud de la Universidad Estatal de California, Long Beach, su título de abogada de la Universidad de California, Berkeley, y un certificado en Derecho Internacional Público de la Academia de Derecho Internacional de La Haya. Es miembro del Colegio de Abogados de California. El Instituto Americano de Derecho la eligió miembro en 1991 y la incluyó como miembro vitalicio en 2016. Anteriormente fue profesora de Derecho en la Universidad de Wisconsin-Madison. En Wisconsin también se desempeñó como vicecanciller asociada para asuntos académicos, encargada de los programas de contratación estratégica de la Facultad, destacando las de mujeres en STM, Ciencia, Tecnología, Ingeniería y Matemática, la de minorías y las contrataciones de grupos interdisciplinarios. También fue la primera vicecanciller de Equidad, Diversidad e Inclusión en la Universidad de California en San Diego. La decana Greene ha tenido una amplia experiencia en la práctica. Fue abogada en el Fondo de Defensa Legal y Educación de la NAACP y una reputada asesora de 34 departamentos de Los Ángeles sobre derechos civiles y política constitucional. Fue profesora asociada en la Universidad de Oregon y en 1984 fue la primera mujer afroamericana en enseñar en la Facultad de Derecho de Harvard. A partir de entonces, fue profesora visitante en el Centro de Derecho de la Universidad de Georgetown, continuando allí como adjunta mientras servía durante 3 años como consejera del Comité Judicial del Senado de los Estados Unidos. En ese cargo se especializó en la revisión y confirmación de jueces federales, incluidos 5 nominados a la Corte Suprema en materia constitucional y legislación de derechos civiles. Fue presidenta del Comité de Legislación del Comité Olímpico Estadounidense, vicepresidenta del Comité de Auditoría de esta misma institución, miembro de la Junta Atlética de la Universidad de Wisconsin y cofundadora de la Fundación de Mujeres Afroamericanas en los Deportes. Su reciente trabajo académico refleja su amplia experiencia. Como publicaciones recientes tenemos y podemos citar Teoría crítica de la raza, Orígenes, permutaciones y temas actuales del año 2021. Y su próximo libro será Hacia una democracia constitucional inclusiva, las opiniones disidentes de Thurgood Marshall. Ha proporcionado análisis mediáticos, políticos y legales durante más de 30 años para una variedad de medios, incluido The New York Times, donde ha escrito artículos de opinión desde el año 1992. Su visita a la Universidad de la Frontera espera potenciar el intercambio del conocimiento, desarrollar vínculos y potenciar la educación integral entregada por la carrera de Derecho y que es impulsada por el cuerpo académico del Departamento de Ciencias Jurídicas. Sin más preámbulo, invitamos a pasar al escenario a la doctora Linda Greene, que presentará su charla magistral denominada Racial Equality and Constitutional Interpretation.
It's a fantastic pleasure to be with you today. I want to echo some of the comments that have already been made about how significant this particular time is for all of us in higher education. In my university, in my College of Law, we are navigating the same issues that challenge you. We're wanting our students to come back. We want to interact with them in our classes and outside of classes and have the experience that makes a university special. And at the same time, we also are navigating the challenges of maintaining our health while we continue to do the important work that society expects of universities. When I first heard of this opportunity, it was May 2021, and a Professor Allard Soto, contacted me. That was a long time ago. At that time, all of our universities were remote in the United States. So at the time that we started work on the project, we didn't know whether I would have the opportunity to come to this important region and also to meet students and faculty from this important university. But I think one thing that characterized our activities together is that we had faith if we continued to persevere, and with optimism that we might be able to make this happen. So I just thank you so much for the opportunity to talk to you today. I want to talk to you today about racial equality and constitutional interpretation. I chose this topic because I think that many of you, despite the fact that you are in Chile, you probably know a lot about what is happening in the United States because we all have access to media. And I thought that of all the topics that might be important at this time, a discussion of racial equality in the United States Constitution might be a great topic. I wanted to talk not only about racial equality, but about how we interpret the Constitution, because your country is in a historic process right now, writing a new Constitution. And my hope is that if I share something about our American constitutional experience with race, that there might be some lessons that you might be able to take away from our experience. A major point I want to make is that in our Constitution, which we wrote in 1787 and adopted in 1789, we use generally very broad language in the Constitution. And because we have very broad language in the Constitution, that means that judges must interpret that language. And so, in general, this broad language gives judges the broad discretion to decide the meaning of the Constitution. Before the Civil War, the judges interpreted the Constitution to provide very broad rights to slaveholders, despite the fact that these rights were not specified in the Constitution. After the Civil War, which was fought over slavery, the Supreme Court narrowly interpreted the constitutional provisions that we adopted to provide freedom for the newly freed slaves. And currently, our Supreme Court narrowly interprets a clause called the Equal Protection Clause to limit judicial intervention into racial discrimination and to encourage judicial interdiction or interruption of decisions that broaden the opportunities of minorities. So I wanted to start with the overview so that you would be able to put in perspective my detail that will follow. The slave trade in the world took place between 1650 and 1860, and I show you this map so that you can see the slave routes, of course, from Africa to South America, to the West Indies, to Central America, and to the United States. And in our country, whites enslaved African Americans from 1619 to 1865. But slavery was not specifically mentioned in our Constitution. However, the framers of the Constitution chose to protect slavery in three ways. So there was one clause, a 3/5 clause, another clause that dealt with the importation of slaves from Africa, and a fugitive slave clause. So in the 3/5 clause, we have a Congress that was made up of representatives from the entire United States, but representatives were determined by the number of people in a particular district. And so, as a way to encourage the southern states to join the Union, the Constitution says that the southern states owning slaves could use those slaves in order to increase their representation in Congress. A slave would be the same as 3/5 of a person, but that would give the members of the Union from the southern states representation. The Constitution also gave a window of opportunity for the continued importation of slaves into the United States. We adopted the Constitution in 1789, and the Constitution gave a period of time to 1808 for the slave trade to continue, and then the slave trade would be banned. So that was a protection of slavery. But the Constitution does not mention slaves, it mentions persons. Finally, the Constitution included a fugitive slave clause, and the fugitive slave clause set in the Constitution an obligation for states that where slaves escaped to return those slaves to their masters. But once again, there's no mention of slavery in the Constitution. No person held to service or labor in one state under the laws thereof escaping into another shall be discharged from such service, but shall be delivered up upon a claim of the party to whom such service or labor shall be due. So one thing that you are able to see about the Constitution at this period is that there is no mention of race. There is no mention of slavery. However, the compromises that the framers made were designed to protect that slavery with these clauses. So we call these the slavery bargains. So in our country, from 1789 and before, there was great disagreement about whether slavery was moral, whether it was appropriate. And so that disagreement was a part of the discussion about the writing of the Constitution. I can take my mask off, right? Did you say? That discussion about the morality of slavery was a part of the discussion of the writing of the Constitution in 1787. And so that tension about whether slavery was moral was built into the constitutional process. The framers of the Constitution decided that they would permit slavery. They did incorporate those slavery clauses without mentioning slavery, but the tension about slavery continued. And so Congress tried to resolve that tension by admitting states to the United States to maintain a balance between slave states and free states. And this slide talks about the compromises. And you can see, this is where my button comes in. Oops, there we go. So we had compromises. Slavery was prohibited. This is 1820, but it was permitted. And then these are territories. And then we go on to 1850, and you see slavery is permitted. These are free territories, and these are territories where the people had the opportunity to make their own decision about slavery. And then in 1854, we see slavery is permitted. These are the free states, the orange states, and these are the territories where the people could decide about slavery. So that's to say that slavery continued to be controversial even though it was permitted in the Constitution. Eventually, the United States had a civil war over slavery, and that war took place between 1860 and 1865. That war, of course, was a product of the conflict about slavery from the beginning of the United States in 1789. However, there were certain judicial decisions on slavery that exacerbated that disagreement between those who favored slavery and those who did not. And I'll talk about these two decisions, Prigg versus Pennsylvania and Dred Scott versus Sanford. What I want to illustrate with these decisions is that in our Constitution, we have very broad language about rights. And in these two particular decisions, the court is interpreting the due process clause of our Constitution. The Constitution says that no state may deprive any person of due process of law. But what is the meaning of due process of law? Where do we get the values that we incorporate into due process of law? And these two decisions illustrate the manner in which the court interpreted that very general phrase, due process of law, to protect slavery. So starting with the Prigg decision, the question was whether a state law that required a slave master who wanted to apprehend a slave in Pennsylvania, which was a free state, whether a state law that required that slave master to go before a court and prove that the black person he claimed was a slave was indeed a slave. And what happened in Pennsylvania, one of our states, a free state, was that slave masters would send people to Pennsylvania, a free state, in order to kidnap slaves they said belonged to them and take them back into slavery. But slave catchers also apprehended free black people and took them into slavery. And there was a lot of violence associated with this. If a slave escaped 1,000 miles to a free state, you imagine that that slave would not go back into slavery willingly. And so Pennsylvania passed a law that provided an opportunity for a slave master to go to court to prove that he owned that black person he claimed was a slave, to produce the ownership papers before the court would permit the slave master to take that black person back into slavery in a slave state. So the question that was presented to the Supreme Court was this Pennsylvania law that required the slave master to use a judicial process to prove that he was entitled to possess the slave unconstitutional? Was it unconstitutional? And in this case, the Supreme Court decided that the law was unconstitutional. But how did the court reach the decision? I told you the entire text of the United States Constitution on the question of slavery. The text doesn't mention slavery, but it protects slavery. So how did the court reach the conclusion that the Pennsylvania law was unconstitutional? Well, it decided that the Fugitive Slave Clause and the protection of slavery was fundamental to the existence of the United States. The Constitution doesn't say that, and so the judges had to decide what values had been inserted into the Constitution even though they were not explicit. And as a result, the court said that the state cannot prosecute slaveholders who refuse to follow judicial process for the return of slaves. Why? Because the United States Constitution provides an unconditional constitutional right of the slaveholder to possess his slaves. Once again, the Constitution says nothing of the sort. And so therefore, the court is asking a question: what are the values that we have incorporated into the Constitution? What are the principles that are fundamental to the Constitution of the United States? And at this point, the Supreme Court says that the unconditional constitutional right of a slaveholder to possess his slaves is a fundamental principle of the Constitution, and that congressional legislation on the subject of fugitive slave return forbids state laws. So as to the last point, there was congressional legislation that provided for the return of slaves to their masters. That legislation Congress enacted based on the constitutional Fugitive Slave Clause. But the congressional legislation said nothing about the question whether states could also pass laws to regulate the return of slaves to their masters. It said nothing about whether state processes to provide for the return of slaves were unconstitutional. We call it a concept of preemption, whether because the federal legislature has acted, whether that action itself precludes the state from acting. And so the Prigg versus Pennsylvania decision is an example of a circumstance where we are asking the question whether the existence of federal law on a topic forbids states from acting. The court cannot answer that question by looking at the Constitution. The court can't answer that question by reading the words of the Constitution. And therefore, it decides to answer that question by stating its view of the fundamental values that were incorporated into the Constitution. They were not stated, but the court says these are the values. And I would add that in making the statement about the values, the Supreme Court could not rely upon any specific discussion about this topic that occurred during the Constitutional Convention. So once again, what I want to illustrate is we have a broad constitutional provision that federal law and the Constitution are the supreme law of the land. And then we have a specific question whether Pennsylvania's statute to provide judicial process before blacks are taken into slavery is inconsistent with the supremacy of federal law. The court cannot answer that question by looking at the Constitution. The court cannot answer that question by reading the text of the Constitution, and it can't answer that question by going back to the discussions that the framers had when they wrote the Constitution. And so therefore, the court decides to read these values into the Constitution. And so Prigg said, look to the nature and objects of the particular powers, duties, and rights with the light and aids of contemporary history. How do we interpret the Constitution? We look to what did the framers seek to achieve? And then we give the word such operation and force, consistent with their legitimate meaning, to fairly secure and attain the ends. The court concludes that the full recognition of the right of slaveholders to their slaves was vital to the Constitution, and therefore that this question must be decided in favor of the slaveholder. I'll go on. So here we have slavery in 1850. The free states here, the slave states here, the territories where slavery was not permitted, and then it was a territory, but slavery would not be here, and then California. So one of the most important decisions that led to the Civil War was the Dred Scott decision. Dred Scott was a slave, and his master took him from a slave state, Missouri, into a free territory. When Dred Scott and his master returned to the slave state, which is the state of Missouri, he sued. He sued for his freedom in a federal court. He said, because my master took me to a free state, I became a free man. And I remained a free man even though my master moved back to a slave state. And so Dred Scott sued in federal court on his claim that he was now a free man. In order to sue in federal court, he had to meet the requirement of federal jurisdiction. And we have a requirement of federal jurisdiction. One opportunity to sue is if you are a citizen of one state suing a citizen of another state. And so the question the court addressed was whether Dred Scott was a citizen of a state such that he could sue in federal court. The Supreme Court answered this question no. And it not only addressed the possibility of whether a former slave could become a citizen because his master moved him to a free state, it also addressed the question whether free blacks who had never been enslaved could be citizens of the United States. And the court says that we were not included among the part of the people. We were regarded as beings of an inferior order. We had no rights that white men were bound to respect. We were justly and lawfully reduced to slavery. We were treated as an ordinary article of merchandise, and that this opinion was fixed in the civilized portion of the white race. And so, oops, did I get it right? Sorry. In addition, in this case, the Supreme Court said that the compromises that Congress made to keep the Union together, that some states would be free, some states would be slave, those compromises were unconstitutional, that Congress had no right to deprive a slave owner of his property just because he took that slave to a free state. That it was unconstitutional to deprive a citizen of the United States of property because he brought his property to a free state. And so, as a result of Dred Scott, blacks born in the United States, whether free or slave, could not be citizens of the United States. Compromises about slavery were unconstitutional, and that slave owners may take these number of people who died in that Civil War. Millions died during that Civil War. And the South surrendered in 1865, and then that gave rise to a new set of constitutional interpretation opportunities. After the Civil War, the United States added three amendments to the United States Constitution. 13th Amendment, that abolished slavery. A 14th Amendment that reversed Dred Scott and said that all persons born or naturalized in the United States are citizens of the United States and the states where they reside. And the one we'll be talking about, no state shall deny to any person within its jurisdiction the equal protection of the laws. There was also a 15th Amendment, and this amendment addressed voting. The rights of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude. We added 3 amendments to our Constitution, and I'm going to talk about the manner in which the Supreme Court interpreted one of those amendments, the 14th Amendment. So how would the Supreme Court interpret these new amendments? Certainly the purposes of the amendments were to provide rights to those who had previously been in slavery. But once again, our approach to interpretation is not set forth in the text of the Constitution. We have various approaches. We could look for evidence of what the framers intended with those amendments. We could look for values in the constitutional provisions. We also have the possibility of what we call non-original techniques. So the original techniques focus on what did the framers intend when they wrote the Constitution, but we also have other possibilities of non-originalist approaches to interpretation. We can look at the text, see what the text says. We can look to natural law, reason, and experience. We can ask the question whether there are unwritten constitutional values. That's very much the approach that the court took prior to the Civil War. We could ask, what is tradition? How have blacks been treated in the United States? And should we carry that tradition forward? We can also talk about our constitutional traditions. Do we aim to broadly interpret personal rights, or is our tradition to narrowly interpret personal rights? Do we aim to broadly interpret the powers of government, or do we narrowly interpret the powers of government? That would be an example. And what about our history? What does the history say about the meaning of the document? And then finally, we could just make an effort to make sense of a document and try to interpret it so that it makes sense as a whole document. So just a little bit about, so we talked about the values that the court used in the pre-Civil War cases. Implicit framers' intent. Implicit versus explicit. There was no explicit framers' intent to resolve the questions presented in Prigg, and there was no explicit framers' intent to resolve the questions that were presented in Dred Scott. The Supreme Court incorporated into the Constitution values about the importance of protecting racial slavery, its value about the custom of protecting racial slavery, its values about the importance of the tradition of slavery to the United States frame. Oops, here we go. And so how did the court interpret these amendments? The 13th Amendment, the court limited violations of the 13th Amendment to what was considered badges and incidents of slavery, meaning those aspects of slavery that were core to slavery, such as confinement. But it said not all racial discrimination violated the 13th Amendment. How did the 14th Amendment change racial inequality? Here, the court asked the question, what does it mean to deny equal protection of the laws? Does denial of equal protection of the laws mean that the state must engage in racial discrimination? Or if the state does not protect the newly freed slaves from racial discrimination, does the state deny equal protection of the laws? The court concluded that only state discriminatory action violated the Constitution, that private people were free to engage in racial discrimination. Whites were free to engage in racial discrimination against blacks. How did the 14th Amendment change racial inequality? The court did say that it was unconstitutional to use race as a qualification for jury service. The court said that in 1880, but the court said it would be constitutional to exclude blacks from voting, from elected office, and from juries using race-neutral requirements. So the slave states had deprived blacks of the opportunity to obtain an education. But the slave states said that in order to vote, you would have to be able to read and interpret the Constitution. The state said you would pay a tax to vote. And so that meant that poor blacks could not qualify. The states imposed educational requirements. And so you had to have attended school. Well, blacks were denied education. And so these were all race-neutral requirements. The state also said, well, you can vote as long as your grandfather voted. So if a state said that in 1868, I am a slave, my grandfather could not vote. Now that is a race-neutral qualification, but it would advantage whites and prohibit blacks from voting. But the Supreme Court said that this was constitutional. How did the 14th Amendment change racial inequality? The court said that state-mandated segregation in train transportation was constitutional. It was permitted after the Civil War. The court said that state-mandated segregation in education was constitutional. So the court interpreted the Equal Protection Clause to permit racial discrimination. Going forward to 1944, during the Second World War, the United States imprisoned Japanese American citizens during the war on the premise that they were a threat. The Supreme Court said that the curfews imposed on Japanese Americans, their exclusion from certain areas, and their imprisonment during the World War II did not violate the Constitution. So when did the 14th Amendment begin to change the situation for racial inequality? That started in 1948 by the court striking down judicial enforcement of private agreements to discriminate in housing. The court said that maintaining all white state law schools without any law school for blacks violated the Constitution. The court said that mandatory racial segregation in legal education was unconstitutional in 1950. And then it said that mandatory racial segregation in graduate school was also unconstitutional in 1960. So these begin the opening periods for the 14th Amendment to begin to change racial inequality in the United States. Sorry, bouncing around here. Yes. Finally, in 1954, the court said that mandatory racial segregation in the United States public schools was unconstitutional because it impairs effective learning, promotes feelings of inferiority in black children, and limits the opportunity of black children to fully participate in society. But the court was not prepared to give a remedy in 1954. When the court returned to the question the next year, in 1955, it did not require immediate desegregation. It did not require immediate desegregation, and Southern states refused to comply with court orders. So the court in 1958 said that a governor's refusal to comply with a court-ordered desegregation violated the Constitution. And then after that decision, Army troops escorted black children to school. That was an example all over the country, the southern states where there was resistance. The court said it was unconstitutional for a state to close all of its public schools after a federal court ordered desegregation. That happened in Virginia. And the court also said that school boards must show that they will make immediate progress in ending state-imposed segregation. The court said that in 1968, but that was 14 years after it decided that school segregation was unconstitutional. After that, the Supreme Court began to limit the ability of courts to impose remedies that would end desegregation in public school. The court did that between 1974 and 2017, and I want to focus on the influences and values that the court brought into its interpretation to decide to limit school desegregation. It talked about the federal system where we have a national government and a state government, and that to continue to intervene in the schools would violate the allocation powers in our federal system. Talked about the importance of local control of schools. It talked about limitations on federal judicial power. It rejected desegregation remedies unless there was proof that the authorities intended to segregate. And today, most schools are still racially segregated in the United States as a result of the limitation on remedies and on the standards for imposing school desegregation. The Supreme Court also limited judicial remedies for other types of racial disadvantage caused by race-neutral standards. For example, the Supreme Court said that the use of tests that disadvantage racial minorities do not violate the Constitution. The Supreme Court has said that the application of death penalty policies that result in disproportionate sentences of death to racial minorities does not violate the Constitution. The Supreme Court said that constitutional violation is only permitted when a minority can prove that the government intended to harm a minority. It's not enough to show the policy disadvantaged racial minorities and advantaged whites. It's necessary to show that the policy was adopted because it would disadvantage blacks or other racial minorities. So what does it mean to deny equal protection? So does a law or program that seeks to provide benefits for racial minorities previously disadvantaged violate the Constitution? Well, the Constitution does not provide an answer to this question, and so we begin to take the question that we are considering today. The Supreme Court will decide a case of this type this year. Are all uses of race forbidden, or only those that were designed to harm a previously disadvantaged minority? So what does it mean to deny to any person within the jurisdiction equal protection of the laws? So just let me state the question again. Now, a college or a university might decide that it previously excluded minorities from education, and now it would like to adopt a policy that will permit those minorities to attend school by taking into account their minority status. So does a policy provide education to racial minorities previously excluded from higher education deny whites the equal protection of the laws? So do government policies that improve the status of racial minorities who have been historically subjected to racial discrimination deny whites equal protection? There have been a number of cases involving the voluntary use of race as a factor in university admissions. No court ordered that use of race. And the court has considered this question a number of times in 1978, in 2003, in 2013, and also in 2016. And in each case, the court has said, yes, under some circumstances, it is possible for a university to take race into account in crafting an admissions policy that will include more racial minorities. However, even though the court recognized that student body diversity is a compelling interest that can justify the use of race, it said that the university must be prepared to demonstrate in court that the use of race is necessary to achieve diversity and that there are no workable race-neutral alternatives. And so any university that adopts these policies must be prepared to go to court to defend the policies, sometimes at the cost of millions of dollars, and always with the possibility that they will go to the Supreme Court so that the Supreme Court can decide the question. Sorry. Great. What I wanted to then end with is to bring this question, my discussion of racial equality, back to the question of constitutional interpretation. And to say, what does the American experience about race and constitutional interpretation tell us about choices about constitutional language on the one hand, and choices about the power of the judiciary on the other hand? So the lesson is that when constitutional provisions are general rather than specific, the content of equality will depend upon the judges. It will depend upon the values of the judges, and it will depend upon their approaches to constitutional interpretation. Right now, we are in the process in the United States of considering the appointment of the first Black woman to serve on the Supreme Court. In the course of that confirmation process in the United States Senate, the senators are going to ask questions not about the qualifications of the candidate per se, but are going to see whether they can determine whether the candidate, her name is Judge Ketanji Brown Jackson, whether the candidate's values are values with which they agree, whether the candidate's approach to constitutional interpretation is an approach with which the senators agree. They will also ask her questions about certain decisions, which she will probably refuse to answer. But if you have the opportunity to listen to those hearings, what you will find is that the focus of those hearings will not be on the specific language of the Constitution, but instead will focus on what values will this new justice bring to her job as a Supreme Court justice, and also what methods of constitutional interpretation she will employ. And so I wanted to end by saying one of the reasons I was so excited to come here is because I want to have an opportunity to learn how Chile plans to write its constitution, how specific Chile will be about rights, or how broad Chile will be when it interprets rights. And as I thought about what I could share with you that might be not only important to your understanding of the United States, but also important to your thinking about your own constitutional process. And that is, you make choices in writing a constitution between broad statements of rights or specific statements of rights. Broad statements of governmental power, say the power of the executive, and specific statements of governmental power, power for the legislature, power for the president, for example. And there are advantages. General statements might permit a constitution to grow and change over time. Specific statements, on the other hand, might prevent judges from determining the meaning of the Constitution without any guidance from the text of the Constitution or from any specific statements in the Constitution guiding that interpretation. And so I think that I have a great deal to learn from you as I learn more about your constitutional process. And I came here to ask you to spend some time understanding the American constitutional experience, just one of many in the world, but spend some time understanding the American constitutional experience so that you can decide what would be the most beneficial choices about language that you will make during your constitutional process. Thank you so much for the opportunity to speak. Thank you. Thank you. My mask. Thank you.
La Facultad de Ciencias Jurídicas y Empresariales quiere agradecer la notable y motivadora presentación de la doctora Linda Greene, a quien invitamos a subir al escenario para recibir un reconocimiento, por favor. hace entrega del presente la directora de vinculación con el medio de la Facultad de Ciencias Jurídicas y Empresariales, doctora Carolina González Sur. Acá al medio. Al medio. Sí. Oh. Yes. Con este reconocimiento concluimos esta ceremonia de inauguración del año académico de la Facultad de Ciencias Jurídicas y Empresariales. Agradecemos la participación de todas y todos. Que tengan una excelente tarde.